Good afternoon. We are delighted to welcome you to the second of our four-part webinar series in which we're looking at how you can resolve your construction disputes. Today we'll be focusing on mediation. This is something of a back to basics webinar series looking at the main dispute resolution options: adjudication, mediation, which is today's session, arbitration and litigation. The law and dispute practices rarely stand still, and it's also always important to keep up to date with the very latest legal and procedural rules, as well as the best strategies and approach for participating in a dispute resolution process. I would encourage you to sign up and join us for all of these webinars, which will be recorded and available on our Vimeo site if you'd like to listen again or to share with your colleagues. So just before we begin, to minimise background noise, I've placed you all on mute. If you do have any questions you'd like to ask, please do so using the webinar chat function, and we will return to answer these at the end. So introducing your speakers today, I'm Kate Gillis, a solicitor in the Construction and Special Projects team. I specialise in construction and engineering dispute resolution, and I'm based in Edinburgh. I'm joined by my colleague Nathaniel Buckingham. He's also a solicitor in Construction and Special Projects team and is also based in Edinburgh. Both Nathaniel and I regularly advise on construction contract issues and disputes across a range of projects and clients. We've been involved in a number of mediations and have acted for employers, contractors, subcontractors and consultants, all across the full range of dispute issues, project types and contracts. This experience helps us to form the basis of our approach and strategic advice for mediation, and informs what we're going to share with you today. What I would say at the outset is that mediation is a very viable and useful dispute resolution option for construction industry disputes. Although sometimes it's dismissed out of hand as being too soft an option, we think that mediation has many benefits and it is a useful device in the dispute toolkit. It may not always be appropriate for every dispute, and we certainly do not recommend mediation simply as a matter of course, but we do always consider it as an option. And we hope that by the end of this webinar, you will too.
Thanks, Kate. We will start today with a brief review and reminder of what mediation is and how it works. We will then look at the benefits and drawbacks of mediation versus other dispute resolution approaches. Finally, we will share some of our practical tips and strategic advice for those participating in mediation by going through the life cycle of a mediation. This will also consider when mediation should be used in a dispute, and most of our tips will be relevant for both sides of the mediation. In the last webinar, we looked at adjudication, which is a construction industry-specific dispute resolution forum. Mediation is not construction industry specific and has a much broader appeal. Indeed, mediation is popular in all sorts of situations, most notably in family law, for example, divorce, child custody and other family disputes, but it's also popular in employment and commercial situations. Mediation, being at its heart simply a facilitated negotiation, has been around for centuries, but it has been the focus of much closer attention since the 1990s. That followed the general attempt to move away from litigation in the 1980s and 90s as the courts began to get busier and slower, and parties were increasingly looking for alternative ways of resolving their disputes. It was during this period that mediation started to be embraced by the wider legal community, for example with the Centre for Effective Dispute Resolution, CEDR, being set up in London in 1989 to promote alternative dispute resolution, including mediation. So there's no fixed definition or process of mediation, but as I said, it's essentially a facilitated negotiation. Typically, construction mediation would happen over a single day or perhaps 2 days, although notably the Edinburgh Trams mediation reportedly took several days. And this is done with an independent mediator appointed by agreement between the parties. At the venue, each party has their own space for discussions and reflections, and there is a bigger space where the parties meet to discuss and negotiate. Parties will exchange position papers and documents in advance, and the mediation typically starts with a plenary session, during which opening statements are made by both parties. The mediator then facilitates discussions of aspects of the dispute, either in a joint forum or individually, as well as discussing the parties' positions and possible compromises with them separately. The target is to get both parties to a place where a settlement can be agreed. Statistics for mediation suggest that around 2/3 of mediations settle on the day of the mediation itself, with many others settling at some point shortly after the mediation. In terms of actually concluding a dispute, that is a very good success rate, and it is certainly borne out in our experience. as we have only been involved in one mediation that is not resolved on the day.
Now let's think about some of the benefits of mediation. As Nathaniel says, mediation has a high success rate, which itself is a huge benefit. This probably comes from the fact that mediation, in Scotland at least, is a voluntary process. Parties will generally only agree to mediate where they can see scope for a settlement being achieved and they actually have a desire to resolve the dispute. There is, however, the possibility of a cynical use of mediation process as an information gathering exercise. Mediation is typically cheaper than running litigation to a conclusion or setting involved in other disputes forums. Although parties will still have the costs of formulating their position and the costs of the mediation day itself, this should still be much cheaper than the full preparations and hearings required in, say, a court action. The cost of taking a dispute to court is usually a significant factor which a mediator will ask the parties to consider when looking at the outcome to be achieved at the mediation itself. That sum alone will often help to bring the parties considerably closer together in terms of the financial settlement outcomes. Specially trained mediators are often experienced dispute practitioners. Costs would typically be between £3,000 and £8,000 a day for their services, depending on the experience of the mediator and depending on the number of parties who are involved in the mediation. This is usually payable equally between the parties up front, and it's likely to be a proportionate cost as compared against each other's parties' internal preparation and participation costs in a reasonable sized dispute. Mediation also allows disputes to be concluded much more quickly than litigation. This itself reduces actual costs, but also allows parties to sort a dispute out and move on, which can also have value to the parties. Compare that with the current court situation, where proofs in the Court of Session, for example, are being booked in for summer 2017. That shows that the time benefit of mediation is clear. Within this modest cost and time framework, though, the whole dispute can be concluded. This isn't always possible in other short, sharp options, such as adjudication, where a large or complex issue may need to be broken down. Linked to the ability to quickly move on after mediation is the question of maintaining relationships. Many parties in construction disputes will have quite a good working relationship initially, and it may sour through the dispute process, but particularly if that process is an adversarial one, such as court proceedings or adjudication. Mediation retains the possibility that relationships can be maintained in a way that is often much harder once you've gone through a court or arbitration process. It's just a much more conciliatory process. Again, experienced mediators are likely to ask parties to consider the cost-benefit of maintaining a relationship, such as future work profits, obviously subject to procurement regulations, etc. And it may be suggested that parties factor that into the settlement calculations, again, bringing the parties closer together in terms of settlement. You will see that there's a theme here. Most of the benefits of mediation can have a cost benefit attached to them, or the benefit of avoiding the cost of alternative dispute approaches, which can then be a significant factor when considering settlements. Mediation also allows parties to retain control over the dispute and the decision and settlement of a dispute, rather than handing over the decision-making responsibility to a third party, such as a judge or adjudicator. This can be quite powerful, as essentially each party is forced to not only consider their own position, but to think about and evaluate the other side's position and point of view, much as a judge would. Ultimately, the parties are much more likely to get out of a mediation a result that they are happy with, as they have decided what the result is. If they don't like where the mediation is heading, then a settlement won't happen. Compare that with court litigation. Often both parties are left disappointed with the outcome as they pass over control to a third party. Linked to the retention of control is the flexibility of mediation solutions. The parties are free to agree and settle as they wish, meaning that creative and flexible solutions can be considered. We've seen mediations where one party really just wants an explanation or perhaps an apology from the other side. That's not an outcome you'll be able to get from a formal court process. Settlements can be about more than just money. They might include repair works, for example, usually with a fallback payment if repairs are not done to satisfaction within a set period. Or information or document provision might be incorporated into the settlement. Being in control of the decision and the flexibility it affords means parties are more likely to get a result which delivers to them what they need to conclude the dispute. A final important benefit of mediation is that it's a confidential process. Mediations themselves are conducted under confidentiality agreements, meaning that discussions can be opened and entirely on a without prejudice basis. If the mediation does not conclude to a settlement, Both parties can leave without the mediation affecting their position in the formal process. If a settlement is reached, then the terms of that settlement will also be confidential. It's likely that all parties will see the benefit of keeping the dispute and settlement out of the public domain in certain circumstances.
So that list of benefits certainly puts mediation in a very good light, but of course there are some drawbacks which I'm going to go through now. Many of these are the other side of the coin to the benefits we have just discussed. So firstly, the voluntary nature of the process means that parties cannot be forced to the table to mediate and settle. So the first hurdle that you have to get over is actually having parties agree to participate in mediation. But even during the process, the parties can walk away at any time if they want to, because there's nothing to bind them to the process. In reality, mediation is unlikely to happen if one party is reluctant, and if it starts and a party walks away, then that suggests that settlement was unlikely in any case. We'll talk a little bit later about the timings of mediation and being careful not to mediate too prematurely. But knowing that either party can walk away does create a pressure in itself, which often draws out more realistic compromise positions on both sides, so that the mediation can progress. As an aside, in England, the courts are forcing parties now to seriously attempt alternative dispute resolution options before litigation, and cost and expenses penalties are imposed on parties who don't engage. Mediation in that scenario isn't wholly voluntary, and there is an argument that it is simply a waste of time and money where one party is just going through the motions, but on the other hand, just simply getting the parties in a room together can sometimes be a big step forward. Cost can also be a drawback, in that if your mediation does not end in settlement, then the costs of the mediation, which will include the mediator's costs and each party's own preparation and attendance costs, are additional costs to any other ongoing costs of litigation. Mediators' fees are usually paid up front and equally between the parties, and of course there is no cost recovery from the other side in mediation unless that is an agreed part of any settlement, and so there's certainly not any cost recovery if the mediation is unsuccessful. Again though, this drawback can concentrate minds at the end of the mediation process as parties consider their options and the outcome if a settlement is not reached. And although for most commercial organisations the privacy and confidentiality of mediation is appealing, there can be times when people or organisations actually want their disputes to be published and publicised. An aggrieved party may just simply want to have their day in court in the hope that they will be vindicated, or perhaps have the other side shown to be wrong. If proving a right or a wrong is the outcome you are looking for, then mediation really isn't the appropriate forum, as ultimately the process avoids deciding on the rights and wrongs of the dispute, but works towards settlement outcomes only. A current drawback, but one which is thankfully receding, is the perception that mediation is a sign of weakness. Some parties, and even some advisors, are reluctant to suggest or recommend mediation in case that sends a message to the other side that you have doubts about your own case or position. As I say, that perception is receding, mostly because enlightened clients and advisors know that disputes are rarely that cut and dry with faults only on one side. This is particularly the case in complex construction disputes, either say about detailed technical issues or perhaps a complicated final account. Mediations are simply not a forum where both sides set out their position and then meet in the middle. It is an opportunity to present your position and realistically analyse the position of the other side. It is usual that a party who realises their position is weaker during the mediation process will give more ground. So if you are sure your case is strong, mediation can still be a good forum to demonstrate that and potentially settle in your favour with the cost and time savings factored in. As I've noted, these drawbacks can be mitigated, for example by considering the timing of any mediation or offer to mediate. In circumstances where mediation works, it tends to be very successful, but that does not mean it suits every party or every situation. And in deciding your dispute strategy, all of these benefits and drawbacks need to be considered. Before we look at our tips and strategies for mediation itself, we will offer some thoughts on when mediation should be used and how to introduce it. Like any dispute resolution option, mediation should always be part of an overall strategy. We noted in the last webinar that adjudication is often more of a means to an end rather than the end in itself. For mediation, though, it is almost the opposite, in that it is a very good way of concluding a dispute, but it perhaps won't be the way to get to the end of a dispute if you're not really at that point yet. When any dispute crystallizes, each party will usually consider its position and then dig in and defend that position. And that is not a conducive place from which to propose or attempt to commence mediation. Instead, we would recommend that parties start some other proceedings first, in order to flush out what is really at the heart of the dispute, and to help each party to understand better the other side's position. So, an adjudication on a bite-sized chunk of the dispute, such as an extension of time claim or a loss and expense claim, could proceed first in order to set out some boundaries of the dispute. That could lead on to a mediation about the overall final account, which might have been impossible to settle by mediation whilst the EOT or loss and expense claims were in the mix. Similarly, formal court proceedings can be useful to make the parties articulate their entire position and to provide documents and vouching to support that position. Again, this approach can help both parties to better understand the other party's position, which will help them to evaluate the possible successes and outcomes of the dispute. That information and knowledge gained may be sufficient to bring the parties close enough together to consider mediation. So we generally recommend that mediation is only considered once parties have a very good feel for each other's position and are at least in sight of some possible way of concluding the dispute. And mediation should be used when it is clear that both parties are prepared to be realistic about the dispute and the realities of resolving disputes. By this I mean that in dispute resolution there are rarely clear winners. Even those who win a case and get costs awarded are likely to have irrecoverable legal and internal costs and have spent considerable time and energy in the process. An informed client will be aware of these factors and, even when they think they have a clear-cut case to win, will be alive to these commercial realities. Similarly, both parties will need to be ready to listen to each other. So again, possibly not right at the outset of a dispute. Listening to the other side is very important in mediation, not only for your own information, but also to ensure that the other side feels the benefit of the mediation process. So if you try to dominate mediation and don't listen, the other side won't really feel that they're part of the mediation, and that might risk them walking away.
Following on from what Nathaniel has just talked about, the first practical tip to consider very carefully is the timing of suggesting mediation in the first place. This is less about strategic thinking, such as when planning an adjudication, for example, and considering the timings of launching proceedings. With mediation, it's more about pragmatically assessing whether both parties are going to be ready and receptive to mediation, and that is the time to suggest it, based on the factors that Nathaniel has just discussed. Once mediation is suggested, there may be a need to sell that to the other party, or even within the client organisation, if they aren't familiar with the process. There are often situations where both sides' advisors can see that mediation is a sensible route to conclusion, but they may have to convince their clients of the merits of the approach. One example of this is a mediation that I did involving a residential occupier on the other side. It was a mid-value dispute that to the solicitors was a prime candidate for mediation, but the homeowner was so angry with what happened to them, they didn't even want to see the contractor. So we set the mediation up so that they didn't have to. They had staggered arrival times at the beginning of the day. There was no plenary session at the beginning of the mediation. But as the day progressed and the mediator delivered some helpful messages, the parties did agree to meet, and it was that face-to-face meeting that was key in identifying what the homeowner really needed in order to resolve matters. Another important step is choosing the mediator. A well-trained mediator will make the process much smoother and ultimately make it more likely that a settlement is reached. The parties will need to agree in advance who the mediator is going to be. It's often the case that one side or the other will have experience of a good mediator and will make a recommendation. If you're on the other side, receiving the recommendation, don't automatically discount it because you think it will lead to bias. It's the parties who ultimately agree and decide the settlement rather than the mediator, so the issue of bias is much less significant than it could be with recommendations, for example, for an adjudicator. It is very important to have a good mediator, so if the other side has a positive experience of such a mediator, then that should only be seen as a good thing. That being said, obvious conflicts of interest will need to be avoided. It's not necessary for the mediator to have an in-depth knowledge of the construction industry, but a demonstrable understanding is beneficial if you're dealing with a highly complex area. There are, for example, a number of advocates and barristers who have a solid grounding in construction disputes and who have also built up strong mediation practices, so they can be a good option. Another important point to consider is whether an assistant mediator might be helpful on the day. Some mediating organisations, for example Core Solutions in Edinburgh, bring along an assistant as a matter of course, although it's not strictly necessary in a two-party dispute. However, if you're dealing with a multi-party dispute at mediation, I would highly recommend the mediator has an assistant on the day to help keep up good communication and to herd the parties into the joint sessions on time. After you've identified your mediator, you need to consider the venue. Sometimes parties will want to choose a neutral venue, but that will cost more to both parties. And the question is, does hosting the mediation in one or other party's solicitor's office, for example, actually confer any real advantage, or is it just a good way of keeping the costs down? Practical considerations include the availability of reliable Wi-Fi connection, printing facilities, and also the physical location of the rooms themselves. They should be on the same level, if possible. I did a recent mediation where the mediator was running up and down stairs all day. Not only did this waste valuable time, the mediator got quite fed up. The large room needs to be big enough to comfortably seat all the attendees at the mediation, and the separate rooms should ideally not be next door to one another. Some third-party venues are well set up for mediation, but others may need you to finish by a certain time, and that's always a factor. It would be frustrating if parties are nearing settlement but haven't yet concluded when the accommodation runs out. Another practical tip, refreshments and food are very important to think about. Mediations are often long days, and both sides will need to keep up their physical and mental energy levels. So don't underestimate how important it is to keep everyone well refreshed and to use breaks as a way of briefly recharging.
It's vital that both sides come to the mediation with people who have the authority to settle. This may mean having the senior decision maker or business owner at the mediation. There is nothing more frustrating after a day of discussions and negotiations than for one side to say something along the lines of, "Sorry, we don't have the authority, so we'll have to come back to you." Most trained mediators will check that authorities are in place in advance to avoid a situation like that happening. This can sometimes be problematic for public sector disputes, as council officers may not automatically have this level or flexibility of authority for a mediation. We have acted both for and against the public sector in mediations, and we know it can be made to work. As part of the preparations for mediation, the public sector party will have to give serious consideration to the range of possible outcomes and settlements and seek advanced authority within that range. That can give the officers attending the mediation the flexibility to actually conclude the mediation on the day, because effectively they have prior approval. And in some ways that's no different really to a private sector organisation putting some thought into their bottom and top line in advance of the mediation day itself. And think carefully about who else should attend a mediation. It is usually helpful to have those at the heart of the dispute involved, and also relevant experts can be important. These people will need to tell their story, and this may include conveying their emotions of the story, for example, how angry or upset a particular situation or action made them. It's very much harder to get that detail and emotion from a written witness statement. However, all attendees must also be prepared to engage in the mediation process. A single aggressive and unengaged character, for example, can alter the whole mood of the mediation, so everyone needs to be prepared to listen to the other side, which can be very hard for those at the centre of the dispute who may just not like what they hear from the other side. We always recommend that parties' positions are set out in writing beforehand, and relevant documents or a joint bundle is circulated. At the very least, this is useful to inform the mediator of the dispute and will help them as they facilitate the mediation. It is equally of value to see the other side's position distilled down. On the day, arrive on time. Not only is this a basic courtesy, but being late sends a message that you do not value the other side's time and just simply starts things off on the wrong foot. Certainly make the most of your opening statements, but rather than rehearsing your position again, focus on delivering your key messages and addressing what you perceive to be the issues most important to the other side. Also, opening statements set the tone for the day, so unless it's specifically a part of your strategy for some particular reason, being aggressive in the opening session is likely to be counterproductive, and we would usually not recommend it. Then during the mediation, it is important to separate the people from the problem. Although the problem needs to come from the dispute story told by those involved, ultimately the problem itself is what needs to be addressed. And similarly, try to focus on your side's interests and outcomes rather than on your position as such. You are not in a mediation to defend and protect your position to the death like you are in other, or can be in other dispute scenarios. You are there to consider your side's commercial interest and to see whether that can be achieved through the settlement discussed. That is why it is important for parties to really think through the outcomes they want from the mediation. What is it that ultimately you want to get in order to resolve the dispute? As mentioned before, this may be more than just money. Once you get through the factual and discursive part of the mediation day and hopefully get to a point where settlement seems possible, the negotiation strategy needs to be considered. This includes whether to make the first offer and if so, what that offer may be, and what non-financial elements are part of the consideration. A good mediator will certainly help this negotiation process, but ultimately it is for the parties to decide their own negotiating approach. I mentioned non-financial elements as we discussed earlier, the benefit of the flexibility of mediation and the outcomes it can offer. It's very important though that you don't lose sight of these during the mediation. Some parties think they can simply agree the numbers and leave the lawyers to document the rest, only to find that some seemingly trivial piece of the settlement jigsaw, not discussed until the settlement is being drafted, is actually a deal breaker for the other side. It is much better to simply get everything out there in terms of what you want and what you have to offer. That way, parties can each attach a value to those things and consider them as part of the wider negotiation strategy. And then at the end of the mediation, the settlement, if achieved, will need to be documented. Parties' legal advisors are likely to have drafted skeleton settlement agreements in advance to be populated with the details agreed on the day. This should be a painless part of the day, but only if the details have been agreed. Settlement agreements are signed there and then, and the parties close the dispute between them. This is a point where parties can move on from the dispute and think again about any ongoing relationship they have and want to maintain.
Thanks, Nathaniel. So that was something of a whistle-stop tour in terms of tips and strategies through the mediation process. It goes without saying that every dispute, and therefore every mediation, is different, but hopefully some of these pointers will help ensure that any mediation that you participate in is a good one. We've come to the end of the presentation section of our seminar, and we hope you find it to be useful and interesting. We still have a few minutes left to be happy to answer any questions you have. If you haven't already done so, then please type these into the chat box now. Whilst you're doing that, I'll just take the opportunity to remind you that we have the two remaining webinars in this series coming up in November and December on arbitration and litigation respectively. We're also hosting two autumn evening seminars next week in Edinburgh on Monday and Glasgow on Tuesday evening. These are replacing our traditional autumn breakfast seminars and will be an excellent opportunity for networking and for catching up with legal updates from the construction world. Full details of these can be found on the link shown on screen, and I would encourage as many of you as possible to attend. We do have one question there. Is there a published standard process for mediation? Oh, sorry, just a moment. Is there a published standard process for mediation with defined appointment standard terms for the mediator? The answer is there are a number of different standard forms. CEDR, who Nathaniel referred to earlier, I believe that they have a standard outline for appointing a mediator, but generally each mediator, in a similar way to adjudication, they'll have their own standard terms and conditions that they use. I referred to Core Solutions in Edinburgh earlier on. We've used them on a number of occasions, and it's just their standard terms. Alternatively, if you're appointing a barrister and advocate, it would normally be the clerk that you would liaise with in terms of identifying the terms and conditions for the mediator to proceed on. They, in my experience, don't differ wildly, but if there's anything that causes alarm when you receive the terms in, then obviously it can be negotiated with the mediator. The second question there, is there any obligation to recommend mediation or any other form of ADR prior to court proceedings, as may be the case with the CPRs in England? That's not currently the case in Scotland, and there are not at the moment any penalties in costs or expenses if you haven't recommended any alternative dispute resolution. But my own view is that it would be part of our professional obligations to consider all the options available to the client. Classically, the only winners in litigation are the lawyers, and that's where the most fees are to be made. But you know, it's certainly what we need to recommend what's in the best interests of our client, and commonly that is an alternative dispute resolution mechanism. The webinar series obviously considers the other possible dispute resolution processes, and as I said at the outset, that we will always consider mediation as a possibility given the success that we've had using mediation in the past in some quite complex and high value disputes, as well as ones at the other end of the scale, because it can be done on quite a cheap basis if you're not dealing with a high value dispute. Well, I think that's the last of our questions, and our time's now up for the day. So I hope you've enjoyed the webinar and found it to be informative and useful, and we look forward to welcoming you to future webinars and to our evening seminars if you're available for those. Thank you very much.
Thank you.